Hi, I'm Chris Chimicles, president of Angeion Group, and welcome to our Leading Litigators series. Our series brings together some of the best and brightest class action practitioners from both the plaintiffs and defense bars, and most importantly, the attorneys that made case law. Enjoy our series.
Hi, I'm Steve Weisbrod. Thank you for joining us for another edition of Angeion's Leading Litigator video series. Today we have Neal Marder from the law firm of Akin Gump. Thank you for joining us, Neal.
Thanks, Steve. It's a privilege to be here. Nice to talk to you this morning.
The first thing I want to ask you about this morning is your new affiliation here with Akin Gump. You've been in another law firm for a lot longer than most people in today's day and age stay at a law firm. It's meaningful. I'm sure our viewers are interested on why the change, why now, and what excites you about your new opportunity here at Akin.
Well, you know, I'm someone who is intensely loyal and committed to whatever I do, and it was a difficult decision leaving a great firm like the one I was at. But you know, Akin Gump is a fantastic law firm. They have a great brand, and they had a specific need for someone to come in and fill a leadership role, mentor the kids, help grow an already well-established litigation practice here on the West Coast, and do something here that's very special that they haven't had someone do before, which is similar to what I did at my prior firm, and that's provide leadership in the class action practice group and actually launch for the first time in the firm's history a consumer class action practice group. And that's one of the big challenges that I've taken upon myself to do here. It's been a couple months, but I couldn't be happier. It's going great.
That's great. So one of the things when I was researching your background that occurred to me is that unlike a lot of class action litigators, you seem to have a legitimate, verifiable trial record, right? And is that instrumental in how you manage these youngsters and what you're teaching them about class action practice here at Akin?
Absolutely. I mean, you know, it's a great question, because one of the things I try and teach the folks coming up from the farm system, if you will, is when you litigate, you gotta be fearless. You have to work as a team. You got to be collaborative. It's not about you, it's about us. And class action litigation, as you know, Steve, historically, these cases don't go to trial. Most of them don't. We can talk later about one that recently did, that I wrote an article about, the money store case. But most of these cases at class certification, it's a watershed event, and 60% of the time, you know, your clients settle. I think it's important to be able to put some fear in the other side, that you're not afraid to take these cases to trial and you've got trial experience. I think that's what your clients want to know. They want to believe that if things don't go well at class certification, you got the chops to go all the way and try a case.
Sure, and then let's do just that. Let's talk about the article you're referring to, because it's my understanding that's one of the rare occurrences where a case did go to trial. Post-trial, there was a decertification motion, and it was actually granted. Can you give our viewers the benefit of your knowledge of that case and how it happened?
Sure.
Thanks.
What a blow for the plaintiffs in that case. They get a jury verdict for $30 million plus, and they end up getting a judgment for only the named plaintiff for $133. Some incredible lawyering by the defense representing Money Store. One of the key things I always tell my clients is, you know, let's keep in mind that although they don't call it, unless it's a labor and employment case, a conditional certification, they call it an order granting certification. It really is only, we got a lot of ball game left to play. And you may have lost the initial battle, but you haven't lost the war. You got an opportunity to further develop the record and seek decertification later. This case is like, makes me more credible now when I talk to my clients, because in this case, the defense moved for class certification after losing at trial, a jury verdict coming out against them. And then and it's similar to, if you were trying a case moving for judgment notwithstanding the verdict. They basically argued in their motion for class certification that the evidentiary record it presented at trial didn't support class-wide proof. And therefore, the plaintiffs didn't have claims typical of the class. And the judge bought it and granted decertification. I think it's a really groundbreaking decision. I mean, everyone has always understood that under Rule 23, you could seek decertification up to the time of trial. Right. But here we have a motion for decertification after a jury verdict. Wow, big case, big decision.
So is your prediction that we're going to see more, well, first, are more people likely to go to trial given the fact that this remedy is, potentially available to them afterwards, or is this an aberration, or is this going to shape litigation theory and not even theory, how people litigate class action cases?
I think there's still the obvious factors that deter both sides from taking a case to trial after certification: the unknown risks, the cost, the expense, the time consumption. But I do think it could change the landscape a little bit. I think the plaintiffs have to give some pause to what might lie ahead, particularly in jurisdictions where there's local rules that require you to file a motion within 90 days, and there may not be that well-developed of an evidentiary record, despite the court's obligation to do a rigorous analysis and the history behind class certification under Rule 23 being just a procedural mechanism. Courts are looking more deeply now at the merits. But in a lot of jurisdictions, there's not a lot of merits to look at because the record isn't that developed. And this case says that once you get into merits discovery and you put a case on for trial, there's still the 7th, 8th, and 9th innings to pitch, and maybe even extra innings where you can, pull a rabbit out of a hat. So I think it could embolden defense lawyers and clients, corporate America, a little bit more to not just buckle under and pay a ransom when they lose on class certification, and it could cause the plaintiff's bar to pause a little bit. I don't know if it's necessarily groundbreaking, but it's eye-opening.
Let's talk about that a little bit, the idea of a ransom. I assume what you mean by that is once there's a class certification motion, there's going to be the cost of notice that has to go out.
Exactly.
How much do you think, in a not bet the company case, in a more typical class action, that informs defense's posture, their settlement posture, knowing that that cost is going to be incurred because of the class certification motion?
It really depends on the company. I mean, there are obviously in a securities fraud class action where you're dealing with publicly traded company, the company's very concerned about investors and how investors are perceiving the certification of a class. The notice cost can be a real big expense and a real big deterrent. I just think there's no hard and fast rules in my experience on that. It's just a case-by-case basis, depending upon the business and the company. I have clients that if there's enough exposure at stake, will rely upon either their own or our PR departments to help level the playing field when it comes to external communications and the impact class notice can have on the goodwill of the company, the loss of reputation, and all of that. But it just depends on the business you're dealing with.
Clearly, the big story in consumer class action defense over the last year or so is Spokio. What are your thoughts? How has it affected you? How has it affected your clients? Do you have any predictions?
Well, that's really the question of the day, the $64,000 question everyone is asking. Look, I think most class action lawyers, whether you're on the plaintiff side or the defense side, have to be pretty pleased that the Supreme Court has been much more aggressive the last couple of years in taking an activist role in deciding issues that are important for class action lawyers to get some guidance on, whether it was Comcast and class-wide damages or Campbell and mootness. You have them dealing with arbitration. There's the Walmart case, Concepcion, and now most recently Spokio. You didn't ask me this, and I'll get to Spokio, but I think regardless of who ends up in the White House, because I get asked this all the time, and who gets appointed on the bench to replace Scalia, you're still going to have an active bench because there continues to be hot issues that haven't been decided. The most notable one is, I think, ascertainability and a divided circuit court right now on ascertainability. It's not part of Rule 23. Courts are really all over the place on how to look at it and when to look at it. And I think you're going to continue to see an active Supreme Court. But on Spokio, you know, I mean, in California in particular, which is where I do a lot of my practice, you're getting more and more cases that are filed where the plaintiff's bar really don't have anyone to say that they've suffered damages and there's class-wide damages, but they've got a statutory violation. For example, the TCPA cases, the data privacy cases, the Fair Credit Reporting Act cases. Historically, they have taken the position that if there's a statutory right that gives them a private cause of action, they have the right to get in the door in federal court under Article 3 and establish a case of controversy. That's what Spokio addressed. And I applaud the Supreme Court for taking the case. I don't think they came up with very clear guidance, as they oftentimes don't, but they at least said that a statutory violation alone is not enough to establish a live case or controversy for purposes of showing an injury and Article 3 standing. I've been beating that horse for years. And finally we got the Supreme Court at least acknowledging that the violation itself isn't enough. What exactly is a particularized injury or concrete harm? That now is for the district courts to struggle with, and if you just look at the last, at the decisions that have come out, and there's been 4 or 5 of them, you can see that they're all over the map. It's a case-by-case analysis, and I think what the Supreme Court has done is not necessarily good for corporate America, but it's going to keep us class action lawyers busy because they really haven't provided any guidance, and it certainly hasn't been a deterrent. You're continuing to see an uptick in class action filings, and you're seeing cases that in some cases they're allowing cases to get past the pleading stages, and others they're not.
Right. No, it has been all over the place. I've seen TCPA cases where they got past the pleadings. I've seen a recent FACTA decision that got past the pleadings, which was super surprising to me given the nature of the violation of FACTA. I'm not sure there's a question in here anywhere. I'm just pontificating. So I will bring us back to a question. You had mentioned that you expect whoever gets appointed, the court to discuss ascertainability or to address ascertainability. I was personally surprised that you didn't see anything in the new proposed Rule 23 amendments regarding ascertainability. Did that take you by surprise? Were you expecting that?
It surprised me a little bit too, because it's not in Rule 23. It's a judicially developed and evolved principle. And I think it's a position or a principle that's developed by the courts to help them with the manageability issues. If you don't have an ascertainable class, do they really want this thing to get past the pleadings all the way to class certification when you've got an overbroad class definition, a class that includes folks that don't have Article 3 standing? It did surprise me a little bit. I kind of wish they had gone the other way, but I think it's going to get there anyway because, as I said, the circuit courts are split. The Ninth Circuit is grappling with it. Different decisions in the district courts in the Ninth Circuit. I think eventually it's going to end up, in the Supreme Court.
Yeah, I think it's inevitable. So Neal, other than the obvious Spokio, which we've discussed, what other trends are you seeing in the consumer bar in general? And more specifically, is there anything here in California where so much of your practice is located that we should be aware of?
Well, if you follow the trends, what we're seeing is a continued, and maybe not surprisingly, uptick in filings, class action filings. Several years ago, with the adoption of the Class Action Fairness Act, people were wondering, does this mean the end of class actions, or the filing is going to go down? To the contrary. Just the data from this past year demonstrates that there's more and more cases being filed on average. If you look at the top 100, they have 4 or 5 more cases already in their warehouse of cases. So more cases are being filed, higher exposure, higher risk cases, and more expense. As far as the substantive matters in California, we're continuing to see the filing of data privacy type cases. I think those are going to continue until the circuit courts and the district courts come out with some clear law on what constitutes harm. Is there really an injury here? And look, I mean, these plaintiffs' lawyers who are filing the food and beverage cases continue to beat down the courthouse doors with the all-natural cases. Now it's the slack fill cases, the nutritional supplement cases. I'm handling a few of those now. Our client base here at Akin is going to continue to see more and more of those type of cases, which I think is really one of the reasons I was brought here to help spearhead the effort in protecting our clients' interests in those type of litigation matters.
Neal, this has been fantastic. I absolutely enjoyed our conversation. I understand why your clients are so lucky to have you, and thank you for joining us.
Thank you, Steve. It was really a pleasure speaking with you this morning.